2 minutes. That's the part of this case I can't get past. Susan Lorincz told detectives she believed Ajike Owens was going to break through her locked front door and kill her. But the call record, as the detectives lay it out, leaves about 2 minutes between Lorintz's first call ending and her post-shooting call beginning. So keep 3 questions with you. What can actually happen in 2 minutes? How secure was that door? And what did the physical evidence show and not show about where Lorincz was standing when she fired? We're going to hear her account, the detective's test of it, the defense expert's answer, and finally the judge's. The legal outcome is not a mystery. A jury found Lorincz guilty of manslaughter by use of a firearm, and the court sentenced her to 25 years in Florida prison. As of July 28, 2026, Florida's official case system still listed her appeal as open. What matters here is how the recorded evidence got the case from that doorway to that sentence. Before we go into the interview room, this is Ajike. Her son Izzy remembered sitting on her bed while she taught him a song called "I Am What God Says I Am." That's one small, ordinary memory, and it matters. Ajike was a person before she became the name at the center of this argument. One piece of context matters here, but it needs careful attribution. In released bodycam, a child alleged that Lorincz had used a racial slur. Her attorney declined comment when ABC asked about that allegation. ABC also reported that a police report recorded Lorincz admitting she had used racial and other derogatory terms toward neighborhood children in the past. That is context in the record. It is not a jury finding about motive. This is Lorintz's second recorded interview. The detective tells her they have spoken with more witnesses and obtained video from around the neighborhood. Then he reads her rights and asks whether she will talk. Listen to the order of that. They are not asking for the story fresh. They are coming back with things they can compare it against.
Okay.
So, Susan, obviously when we spoke the other night, it was kind of a lot of things going on still. A lot of the pieces of what happened were still trying to be put together.
Mm-hmm.
Since then, we've obviously talked to a lot more witnesses who were there. We've gained access to some video from around the area of where your complex is located. Mm-hmm. So during those interviews, during that process of obtaining new stuff, obviously it brings new questions that we wanted to kind of cover with you and try to verify some of the stuff you said, as well as clarify things that we don't quite understand. So I was hoping that we could do that today.
Okay.
Obviously, just like last time, I want to make sure that you understand your rights and everything. So before we get started, I just have to read you the same thing I did last time. Yes.
Okay.
Okay. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer with him, have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to execute these rights, not answer any questions, or make any statements. Do you understand each of those rights I've explained to you? Okay. And having those rights in mind, you willing to talk to us now?
Yes.
Now listen to the sequence Lorincz gives them. First pounding, then a quiet stretch, then more pounding, yelling, and what she says was a death threat. Don't treat that threat as settled fact. Treat it as what it is here, Lorintz's account of why she believed the danger was moving through the door.
So one of the things I wanted to clarify with you is and try to understand better is when Ajike was at the door, when she approached the door, when was it that you realized that it was her coming to the door?
Because I said, "Who's there?"
Okay. How did you know someone was there initially? Was it because...
It was a huge banging.
Okay.
Just pounding at that door.
Okay. So initially there was no words, it was just the pounding.
Yeah.
That's what started the interaction there?
Yes.
And where was the pounding at initially, where it first began?
The front door.
At the front door?
Yes.
Okay. How many times did she was it just like
it was
like one or
no,
was
no,
it
no,
several?
it was just bang, bang, bang,
Okay.
bang.
All right. And then you said you asked her who's there? Okay. And what was said then?
I think she said, why do you speak to my children this way? And I said, listen, I'm not going to speak to you. Go away. You know, if she had a problem, she should have called you guys. You know, honestly. I mean, if she really thought there was something seriously wrong, I don't understand why she just came over and just started pounding on my door and, you know, screaming and yelling. So.
The first account now has a clear sequence: pounding, a question through the door, and then quiet. The claimed death threat has not appeared yet. It enters only when Lorincz says the pounding starts again.
Go away, and then it got quiet for a bit, and then she started really banging, you know, just pounding on that door. She was relentless.
How long is a bit, would you say?
I don't know,
Like
because
5-10 seconds or 2 minutes? Or?
It was an extended period of time, probably 20 to 30 seconds, easily.
But during that time, you didn't hear anything else? Did you think she went away?
No, well, I obviously knew she didn't go away because she was screaming while she was pounding.
Describe that. When you say screaming, describe what does that mean?
She just, you're not supposed to speak to my children this way. Why did you, you know? And then she was saying, I'm going to kill you. And I'm like, holy shit, you know. And that's when
Well, you said there was like the initial barrage of the pounding, and you said, who's there? And she said, you know, what you said about not talking to her children that way.
Yeah.
And then you said it got quiet. So there was no banging, there was no words being said.
Because I thought she went away.
That's what I was asking. Basically, I'm sorry if I.
No, it's okay. I thought, all right, you know, she's just going to do whatever she wants to do.
And you said that was like 20 to 30 seconds?
Yeah.
And then did she start yelling again first, or was there more banging?
It was banging, it was yelling. I thought she was just going to break down the door.
Okay.
So, I mean, my heart was pounding, and I was like, she's really going to kill me.
Okay,
That's
so.
all I felt.
Her story has something investigators can test. It has an order, and it has time inside it. She describes the second round as lasting long enough for her to search for a phone, think about police arriving, retrieve the gun, fire, and then keep searching until she can call again. The next question is simple. How long does she think that took? Listen for two answers in this next exchange. Lorincz estimates 2 to 5 minutes from the renewed pounding to the shot. Then she says she found her phone only after she fired. Hold on to both answers. The phone record is going to put a hard edge around them later.
That first, I'm sorry to go back, but that first time that she pounds on the door, how long do you think that lasted before there was kind of the silence? I know you said she hit the door, you said who's there, and that what was it said?
Probably 5-10 seconds she was pounding the first time.
Okay. And then when it started again, how long, and I'm going to jump ahead just a little bit, but we'll kind of come back. When she started pounding on the door again and saying all that stuff to the point where you fired the gun, how long do you think that lasted?
2 to 5 minutes.
2 to 5 minutes.
I don't know. Everything's kind of, it was a while. I mean, it was a while. And I kept thinking, okay, you guys are going to show up, you know, because I had called earlier and no one was coming. I'm like, shit, I couldn't find my phone. And she was just banging and banging, screaming at me, telling me, I'm going to kill you, I'm going to kill you. I'm like, she's really going to kill me this time. That's all I kept thinking. She's literally going to come in this house and kill me.
Okay. When did you find your phone? At what point?
After I shot her. I just started searching the house frantically until I found it, and I wanted to make sure that I called and said, you know, I shot, because I heard her go, ugh. You know,
where was your phone?
I think it was in my computer room.
In the computer room? Okay.
This is where fear and evidence begin to pull in different directions. A terrified person can experience seconds as minutes. That doesn't make the terror fake. It also doesn't make the clock negotiable. The fair question is whether the facts outside her memory support the jump from fear to firing through the door. The detectives test that jump in 2 parts. First, what was the shot meant to do? Lorincz says she meant to hit the door and scare Owens away, not kill her. Then the detective describes what he found when he inspected the frame, the locks, and the door itself. Watch how quickly this stops being an argument about tone and becomes an argument about a physical barrier.
And I just kept thinking of that and how terrified I was.
Was your goal to shoot and kill her?
No.
What was your goal?
To shoot and hopefully, you know, she'd hear the shot and dissipate.
But you took aim at the door, is that right?
Yes.
Okay. And the goal was to strike the door and to dissipate it. I'm having a really hard time making this jump here, that this unarmed person on the other side of the wall is somehow gonna get into your house and kill you. I'm just really having a hard.
That answer fixes the claimed purpose. Lorincz says she aimed at the door to frighten Owens away, not to kill her. The detective's next question is whether the barrier made that choice reasonable.
And this is a block house with a solid door. I've seen cases before where there is an angry spouse and say, let me back in the house, you can't throw me out, and they'll kick the wall as hard as they can, and they're not getting in some of these doors open inwards, outwards. I don't know which way your door opens. Which way does it open? It opens outward?
I think it opens out.
Okay. So
It opens inwards.
It opens inwards. Okay. So they work on these doors and they're not even able to make entry, and they just give up. And I'm really having a hard time understanding like how if you could go back in time, would you not do what you did? Would you take it back and I don't know, wait however long it took for the police to get there? I'm trying to understand that. Do you feel like you did something wrong here?
I did what I felt I had to. I honest to God.
Until now, the detective has been testing her belief from hindsight. He is about to move to something memory cannot change: the frame, the locks, and what happened when he pounded on the door himself.
So I went out to the house that morning, when I met you out there, and I tested the door. First of all, I looked at the door. We processed the door just to see what areas might have been touched by AJ. I looked at the door frame where it had been repaired. It looked like there was a type of putty or something used where the wood frame had been separated. I examined the deadbolt lock. The strike plates were in there pretty fastened, pretty securely. The bottom lock, just the doorknob lock. And even with the door closed, I stood on the outside. There were no indentations, no dents in the door anywhere that I could see. And I pounded on the door pretty hard, and that was with the door unlocked completely. There was no lock secured, and that door was.
The important detail isn't that the door made no sound when it was hit. The detective says things inside vibrated. The important detail is that he pounded on it hard while it was unlocked, and it barely moved.
Very sturdy. And I'm not trying to take away the fears of being scared and everything, because I think that is a legitimate, scary situation to be put in. But to justify to go from being scared to a point where you're taking deadly force on someone who's standing on the other side of the door and you don't even know where you're shooting at, that's a big jump. And I think that's where Detective Pender is.
It could have been one of the kids standing there or something.
But it was her standing there. I mean, I heard her voice.
Sure, but some people don't talk. They're more quiet.
Regardless of that fact, as I was saying, to go from that, and I didn't even have any locks, and I'm pounding on it. And yes, there were our forensic technicians were inside looking, and yes, things were vibrating, but they also stated that the door didn't seem like it was going to move, and it barely budged, even with the door unlocked. So. And that's why it's important for us to go through these things to try to.
So what do you make of that? Does the noise explain the fear? Maybe. Does it explain firing through a locked door without knowing exactly where everyone outside was standing? That's the gap the detectives keep pressing. And notice what they don't do. They don't tell Lorincz she wasn't allowed to be frightened. One detective calls it a legitimately scary situation. Their point is narrower. Being scared and using deadly force are not the same decision. The door, the unknown position outside, and the uncontrolled path of the shot all sit between those two things. Later, the interview turns to Lorintz's internet research about self-defense and stand your ground. This can sound more conclusive than it is, so listen carefully. The detectives ask whether she researched the law. Then they ask whether she did it to set something up. Lorincz says no.
Okay. I have to ask you this: have you done any research on like the laws as far as like in Florida, as far as self-defense and things like that?
I looked at it today.
You looked at it today?
When I was on Facebook, just some things that they had it up on Facebook.
Describe that. What did you Specifically, what you were reading about and learning about?
Just, they said self-defense, and I'm trying to think what the hell else I looked at today.
A same-day Facebook search establishes that she saw self-defense material after the shooting. It does not tell us what she knew or intended before the shot. The detective now asks about earlier research.
So much crap. Mostly emails. But I just remember seeing self-defense, and there was a bunch of lawyers and stuff like that.
So, prior to today, even the last time that you and I spoke on very early Saturday morning, you had used some of that same kind of terminology in describing the situation that occurred at your front door. Prior to today, had you ever done any kind of research like that? And before I ask, let me just say, if we were to look through everything in your phone or your home desktop computer, is there anything kind of research on your internet history that would show that you've done research on like self-defense? Or have you ever heard of the term stand your ground?
Yes.
Have you ever done any kind of research on that?
Yes, when it was mentioned on some guy shot someone at a convenience store, and they said stand your ground.
Her answer separates an older memory of stand your ground from recent preparation. The next part tests that distinction against her devices and asks the question directly. Was anything set up?
We're talking about within the last few months, would there be, because your internet browser, even if you delete it or you go on private browser, if you know, we take a look at those things, because we did go through your phone, the judge ordered, signed an order for us to be able to do that. He agreed that there was reasonable enough evidence to be able to do that. Okay. So if that were the case, if we were just to look through that, would there show anything that you were looking up, stand your ground or self-defense laws in Florida on the internet?
I don't know, I look up tons of stuff.
Is it a possibility that you looked that up?
Could have been, I don't know.
A search can show that a search happened. It cannot establish motive by itself. This exchange gives investigators a question and gives Lorincz a denial. It does not give us permission to turn suspicion into premeditation. The stronger evidence in this interview is still the part that doesn't depend on guessing what was in anyone's head. The timestamps. Here is the clock. The detectives say Lorintz's first call began at 8:54 and ended at 8:59. They say the call after the shot came in at 9:01. Lorincz answers that the confrontation seemed much longer. Listen to the full exchange, because this is the promise from the opening coming due.
Okay, so while I was out there going through the notes and everything, I went through, so when someone calls 911, as soon as that call goes to our communication center, it logs it, gives us a timestamp. Hour, minute, second, from the very first time that call was received to the time that it's disconnected, okay? And that's for every single time someone calls. So the first time when you called 911 talking about the boys out there trespassing and things of that. So that call started at 8:54 p.m. Does that sound about right?
Yes. I really wasn't looking at the clock or anything. I just remember calling.
That's what time it says on our call center. And that call lasted for 5 minutes and it disconnected. At 8:59, deputies are on the way. Okay. Now you estimated that it was approximately 10 minutes after you disconnected until the AJ started pounding on your door. Is that correct? Is that what? Okay. So the second 911 call where you called, lady was banging on my door, I shot her through the door. That call came into our call center. It was received at 9:01, which is 2 minutes after you hung up with the communication center the first time. So that's 2 minutes that all these things that you say occurred happened at your front door. From pounding and pounding and pounding and pounding, I'm going to kill you, all these things. Within 2 minutes, she showed up at your front door and did all these things to the time that you pulled the trigger, went and found your phone, and then called 911. So, and that's why I'm trying to get...
To me, it seemed like that amount of time. That's why I thought it was that amount of time.
Less than 2 minutes does not tell us every word spoken at that door. It does tell us the maximum shape of the event. All of it has to fit. The arrival, the pounding, the words spoken, Lorincz getting the gun and firing, the search for the phone, and the second call. So ask yourself, when her sense of time and the call clock disagree, which one can the case actually measure?
Well, so clearly we've established that that was not true, that,
Okay,
that that's not the
understood.
case, but that's what you felt it was.
It
So
felt
you
like
also
that.
told me that that's what you heard, that she was
Yes.
going to kill you. Is it possible that she did not say that, and that's what you heard or you believed, just like you believed it was 10 minutes between those calls?
I just thought she said, I'm going to kill you. I mean, that's what I heard. That's why I was so in fear of my life. I was like, Jesus Christ, she's pounding on my door. She's going to break in. She's going to kill me.
But is it a possibility, if you believe that there was 10 minutes to 15 minutes, adding in 10 minutes before it started, and then approximately another 5 minutes on top of that, that you believe that 2 minutes was 15 minutes, was it a possibility that maybe you thought you heard that, but it wasn't that what she actually said?
I have no idea. That's what I heard.
Okay.
I'm telling you what I heard.
The detective has moved from a proven timing error to a possibility about the alleged threat. Lorincz does not concede that point. She says the threat is what she heard. That distinction must stay intact.
That within 2 minutes, because we know it's 2 minutes, within 2 minutes, this person came over and they were able to put down a series of statements, such as, and you said this, that they came right up to and they want to have a discussion with the way that you were treating their kids that day. You said that they were able to make that sentence. I want to talk to you about the kids. I'm banging on the door. I want to talk to you about the kids. They're making statements like that. We've interviewed other people that it was a very brief interaction, and then you shot them. Now, this wasn't a long siege. It wasn't a castle siege. It didn't last for 20, 30 minutes. It was 2 minutes. So you're trying to tell us that a reasonable person would shoot somebody for less than 2 minutes of making statements outside. That doesn't make any sense. So that I have to look on the scale here. Where is Susan? Did she plan this? Is she a cold-blooded killer that plans things? Was this an accident, or was this something that got out of hand? Is it somewhere in the middle that makes more sense? Not what Susan's telling.
That's the midpoint change in this story. Up to now, the account could stretch or shrink with memory. After the timestamps, it can't. The dispute is no longer whether the event felt long. It is whether a belief formed inside that brief window made firing through the door reasonably necessary. The clock doesn't answer that legal question alone. It makes the question much harder to avoid. By the end of the interview, the detectives tell Lorincz where they have landed. In their assessment, the evidence doesn't justify the shot. They tell her the state is charging manslaughter. Lorincz does not withdraw her account. She says again that she feared Owens would come through the door.
Looking back on it now, and do you think that she was actually going to get through that door? I mean, be honest with us, because
I thought she was coming through the door. As God is my witness, I thought she was going to come through that door. I'm sorry, it's just what I felt.
so, I mean, at this point, like, we've talked to you, we've talked to a lot of people and gone through the evidence. We've discussed all of this with the state attorney's office as well. You know, after talking to you for several hours on Saturday morning and then today, I feel that there was a level of fear, but from everything I've seen, it doesn't rise to the level for you to justify shooting through a closed door and with a firearm. Okay, and I think you know that wasn't reasonable what you did.
I felt so terrified. I just felt so terrified, you know, here she comes again, you know, again.
This is the investigators' conclusion, not yet a court finding. They accept that she felt fear, but say the witnesses and physical evidence do not support firing through the closed door.
I saw 4 kids that no longer have a mother. And I'm not taking away how you were treated, but those are children nonetheless, right? And now they don't have a mother to go home to.
The children's loss explains the consequence of the shot. It does not by itself decide self-defense. The detective now returns to the measurable point. Deputies were coming, and the interval was 2 minutes.
I think you know that there were already deputies on the way.
But there was times I called and the deputies never showed up.
I understand. It's been
So-
2 minutes. So you.
To me, it wasn't 2 minutes. To me, it was much longer. In my mind, it felt like.
But
an
there's
eternity.
only one reality where time
Okay.
exists. And I understand perception of time can be different for different people. But in the reality of things, you had just disconnected. Within 2 minutes, a shot was fired through that door. There was that much that transpired within that 2 minutes where statements were made. I want to know why you're throwing stuff at my kids, or whatever it was she was saying. And then shot fired, and she's down, and then another 911 call comes in. There's no way to justify that. In my mind, I don't think in Detective Pender's mind,
I can't make
and
sense of it.
clearly in other people's minds that we've discussed this case with the state attorney, our legal counsel, and things like that. So, I mean,
The reasonableness argument is complete. What follows is procedural. Investigators say they consulted the state attorney, and the next statement is the charging decision, not the later jury verdict.
at this point, we've discussed it with the state, and they are on the same terms as far as charging you with a manslaughter, okay?
Okay. I don't know what to say. I was in fear for my life. I mean, honest to God, I just feared that she was going to come through that door. I'm sorry, that's how I felt. I can't change the way I felt. I mean, it was sheer terror on my part. I mean, honest to God, I was shaking.
A charge is not a conviction, and an investigator's conclusion is not a jury verdict. This is the contemporary decision that moves the case into court. The jury would still have to hear the evidence, hear Lorintz's self-defense claim, and decide the case under the instructions it received. The physical evidence did not belong to only one side. Lorintz's defense called a ballistics expert. He discusses the cartridge case on the kitchen counter, the near-straight defect through the door, the measured height of that defect, and the absence of soot or powder evidence he could see in the photographs and reports. Listen to what his conclusions actually cover.
Chair when she fired.
If she was standing in front of the kitchen, close to the little table and chair area, how did the cartridge casing end up in the kitchen area?
I think the most likely scenario would be that it bounced off that painting or that wall.
You're talking about this painting right here?
Yes.
Okay.
Yeah, I think it would have likely bounced off that. It's hard to be 100% sure, but just knowing how cartridge cases act when they eject from a firearm, looking at the hole in the front door, and seeing that it doesn't have a lot of azimuth angle to it. It's pretty much, it looks like it went in at 90 degrees with a slightly downward angle. I think that she was probably facing that door, and so the cartridge case would have bounced or ejected back into the right and potentially off the wall onto the countertop is what I think would have happened.
And let's go to the next photo. And this is the painting that you're speaking of, right?
Yes.
And this is the table and the chair area that you said she was right next to or around?
Correct.
So would you say she was right around here or so?
Yeah, I would say that would make sense.
Based on where the cartridge casing was found in the kitchen area?
Correct.
The cartridge case is the expert's first anchor. Its location, combined with the nearly straight defect, supports his estimate that Lorincz faced the door from inside the kitchen.
Where was the bullet entrance located on the door?
I believe it was 4 feet 4 inches off the ground, and I think it was 9 7/8 inches from the open edge of the door.
Okay, I'm sorry, can you say that one more time?
Yeah, it was about 4 feet 4 inches from the ground, high on the door, and then I believe it was about 9 7/8 inches in from the edge of the door. That is the open edge when you open the door.
Okay. And the entrance and exit of the hole were both the same distance away from the edge of the door?
Yes, from what I could tell from the photos, they look to be good photos, taken correctly. They look like they're about the same. I mean, I could be off by maybe less than 1/8 of an inch, just because it's a photo, so I can't be exact. But that's what it looks like to me. Is they look like they're about the same distance away from the edge of the door.
Now the measurements at a second point. The entrance and exit sit at nearly the same height. The remaining testimony explains why that makes the path look almost straight through the door.
And the exit hole was below the entrance hole?
The exit hole was about an 1/8 inch below the entrance hole from what I could see in the photographs with the tape measure.
Is that significant to you?
No, that's not like a drastic downward angle. This hole is pretty round. It looks like it struck at about 90 degrees. Now, between 90 and 70 degrees, a hole is going to look round. It's not until you start getting at more acute angles that you really start seeing an oblong effect to a bullet hole. So this hole looks pretty round. So yeah, it looks like it went straight through.
And did the photographs look to be taken correctly?
Yes, for the most part, they're photographs when you're doing crime scene. You want to really get down at eye level to a defect and take that picture. You don't want to be standing over the picture and looking down or looking up or to the side. You really want to just get straight on and photograph at 90-degree angle. And I believe for the most part that was done in this case.
That completes the trajectory portion. The defect is nearly level and nearly round. The examination now shifts from direction to distance, using soot and powder patterns.
What are gunshot residues?
Gunshot residues are partially burned and unburned gunpowder particles and lead residue and soot that comes out the end of a firearm when it's fired. These residues, much like a flashlight, if you put a flashlight to a wall, against a wall, and start moving back, that diameter of that light will get bigger and less dense, and these powder particles act the same way at different distances. Up close, you'll see a lot of soot and powder. As you get further away, the soot and powder pattern will grow larger in diameter and less dense.
In this specific case, were there any close range gunshot residue drop-offs?
I didn't see any residues in the photos, and I didn't see anywhere in the crime scene notes or report where they were mentioned.
And there weren't any present on the door?
No residue appears in the photographs or reports. That matters only if we understand what residue can establish. The expert is about to explain both the distance inference and the surface limitation.
Not that I can see.
Okay, and what does that tell you?
So this is just a way to do distance determination. So we know that soot drops off at about 18 inches, and a powder pattern will drop off around 3 feet. And so really what these residues can do is give you a distance away from an object, a distance from the muzzle, which is the end of the firearm, to an object.
So that tells you that in this specific case that Miss Lorincz wasn't, based on what you've seen in the pictures, Miss Lorincz wasn't close to the door when she fired.
Right, and I wouldn't expect, just to clarify, a lot of powder to stick to a non-porous surface like this door, but soot would definitely be present if it was close. But powder may have a harder time sticking to the door. But again, if she was 3 feet from the door, the cartridge case wouldn't have landed on the countertop.
The expert's analysis supports a position several feet back rather than right against the door. That matters. It answers part of the geometry. It does not answer the whole case. Distance and trajectory can tell a jury where a shot may have come from. They cannot decide by themselves whether deadly force was reasonably necessary. Physical consistency is not the same thing as legal justification. At sentencing, the camera stays on Lorincz while the judge speaks. The court TV mark remains on the source, exactly as it appeared. The judge is going to address the mitigation, the locked door, whether Owens tried to enter, why he views the shooting as unnecessary, the difference between manslaughter and murder, and the sentence. I'm not going to interrupt him.
I do find that the defense has produced evidence that she would qualify for departure because she has for a mental disorder. I think they found, I find they've proven she has PTSD, which is a recognized mental disorder, and is unrelated to substance abuse or addiction, and that she is amenable to treatment. So I do find she would qualify for that departure. On your second one, the capacity of the defendant to appreciate the criminal nature of the conduct, I don't find there was sufficient evidence to prove that departure. There was no indication that she ever did not understand what she was doing, or that shooting at a person would be against the law, or that she couldn't conform with the law in any way. As a matter of fact, she seemed to be, prior to the shooting, calling the police. So it didn't appear to be any situation where her capacity was impaired in any way. I don't find there's evidence that the victim was the initiator, willing participant, aggressor, or provoker of the incident. Otherwise, although she was knocking loudly in this case, there was no real attempt to get in the residence. She kept asking her to come outside. So I don't find that that departure ground has been met.
The judge has separated 3 departure grounds. He accepts post-traumatic stress disorder as proven, but rejects impaired capacity and does not find Owens to be the legal aggressor.
Despite the existence of one legitimate departure reason, even if she did qualify for the other 2 departure reasons, I would not depart in this case because I find that the aggravated nature of this case and this offense and the harm inflicted outweighs the mitigation or the departure when I weigh the totality of the whole case. So I find that the seriousness of the offense outweighs any legal departures that could be applied in this case.
Even with one legitimate mitigating ground, the judge says the aggravated nature of the offense outweighs departure. He now identifies the harm he is weighing on the other side.
I'm primarily looking at the harm inflicted upon not only the victim, who of course lost her life, but her family. She has 4 children, all of whom were present during the offense or somewhere in the general vicinity, or at least home. It certainly will have a traumatic impact on their lives for the rest of their lives. They'll live their whole lives without their mother, which I think is a very significant harm inflicted upon them by Ms. Lorincz.
That is the victim impact side of the ruling, Ajike's death and the lifelong loss to her 4 children. The judge now turns from harm to the choices made behind the locked door.
When I look at the nature of the offense, I find that the shooting was completely unnecessary in this case. Ms. Lorincz was behind the door was locked. She had already called law enforcement, they were en route. She knew they were en route. She was in a relatively safe position. For some reason she went into her room and found a gun. She could have stayed in the room and put another locked door between her and Miss Owens, but she came back out, put herself in front of the door, and at the time she fired the gun through the door, she was safe. Miss Owens was simply, although she was clearly banging loudly and was probably very angry over the whole situation, it appears to be she was mostly demanding that Miss Lorincz come outside, which would indicate she had no indication of coming inside the house. So when Miss Lorincz fired the gun through the door, she did so knowing a person was directly on the other side of the door. And she knew that person wasn't a burglar, she wasn't a robber, she wasn't a rapist. She knew she was probably upset about the interaction with the kids, but she'd had arguments with her before and no real harm came other than, I guess, a sign was thrown at her, a paper sign. And that's when she decided to shoot.
This is the court's necessity finding. The door was locked, police were coming, and Owens remained outside. The judge says the shooting was unnecessary. He now explains why the conviction was manslaughter, not murder.
I find that the shooting, when I listened to every aspect of the trial and every aspect of sentencing here, it's the facts don't rise to a murder charge, but they are very aggravated manslaughter. Because this case, the shooting was based, I find, more on anger than fear. I think that's pretty well established in this case.
The judge attributes the shooting more to anger than fear, while also recognizing Lorinc's abuse history and lack of a criminal record. What remains is the sentence produced by that balance.
So when I weigh it out, and believe me, I find that, she's a victim of child sex abuse was a significant mitigating factor. And she has no criminal record, which is also a significant factor. However, we also have a tremendous harm inflicted upon this family and the victim's family. So what I'm going to do in this case is she being adjudicated guilty of manslaughter with a firearm, and order to serve 25 years in the Department of Corrections. With credit for 538 days. It's $100 cost of prosecution, $100 fine, court cost. Good luck to you, ma'am. You have 30 days to appeal.
That is the legal endpoint the available record supports. Lorincz stands convicted of manslaughter by use of a firearm and received a 25-year sentence. Her appeal was still officially listed open as of July 28, 2026, with no completed merits decision established by the accessible official snapshot. The judge found that post-traumatic stress disorder had been proven. He did not accept that it made the shooting necessary. For me, the case comes back to the same three things: 2 minutes, a locked door, and a decision that could not be taken back. But Ajike should not be reduced to the worst moment of her life. So remember the other image too, a mother sitting on a bed, teaching her son a song about who he is. That's where I want to leave her. I am Carson Morgan. Until next time, stay curious, stay safe,